Where is the order which sought to be reviewed?
My lord. My lord, before I
Where is the order?
my lord, order is that you not say
What is the
Except
date of
to
the order?
page 24. Start from page 24. But before I take your lordship to these things,
No,
and-
please tell me.
Yes.
This is
no,
the
no.
order
What I am submitting your lordship.
Just 1 minute.
Yeah.
Have a patience.
My
sir.
lord, my lord, my
Have
lord,
a
my lord.
patience. Let me go through
Yes.
the order.
Yes, sir. Yes. Yes. Review your lordship kindly see that this is a matter which arises out of an interim order of the
Where
single
is the
bench.
interim order?
Interim order, your lordship. Read up. Please.
Where? Have you annexed?
My lords.
You are taking
Annex
this
one,
key,
Your Lordship.
then you
Annex
should
one.
annex the interim order.
Yes.
The order
Page
before
21.
challenge.
Page 21, Your Lordship.
21.
Yes. Page 21.
It was passed in the main writ application.
Yes.
Only
Writ
thing it
application
was
interim order.
only thing it was not written that time is disposed of.
Just
No, ma'am.
Yes.
what
No,
is the, we have to look at the nature of the
Yes.
interim.
Your Lordship.
The nature
Yes.
of the order is such
Yes.
that it really finally disposes of the writ petition.
Ma'am.
Why the matter was kept by the single bench was to
Yes.
ensure that what have been directed therein, whether those have been complied or not. That was the intention of the single bench.
Yes.
But if we look at the entire observations,
Yes.
the single bench has virtually disposed of the writ petition on that score.
Ma'am. Ma'am.
The
Right.
court directs the bank authority to settle the matter. Has
Yes.
they settled the matter?
Means finally settle the matter. Your Lordship.
Have they settled the matter?
No.
No. Then the division bench has
Yes.
directed
Yes.
in the impugned order, this order.
Ma'am.
It says
That
that
AI say is to
what modalities have to be adopted, and says that these are the things you have to do it within a time frame.
A bank has complied.
And
With
virtually there is no point of keeping that particular writ petition pending.
that is still pending, Your Lordship. That shows it's pending also.
There was no.
No,
It's
thereafter,
not
Your
writ
Lordship.
appeal is disposed of,
Yes.
modifying that order. In that event, there is no point of keeping the writ petition, and there is no
No, thereafter.
inhibition
Yes.
or obstacle on the part of the appellate court, particularly in a writ jurisdiction, to take up the file and dispose of the writ petition finally. The only point which you can raise before the court was that why a litigant would lose one forum when you have been given a
No, that is
substantive relief.
that is one part. That's the technical part, Your Lordship. Your Lordship is correct. But the other part is that on merits, Your Lordship, the point which was raised by the company, the ASI, that is the insurance company, well, this relates to the Kharif 2011 years. And we are undergoing those Kharif policies from year to year basis. And once the year is complete, that policies and the provisions are closed years. If thereafter any dispute arises, it is for the bank to pay yours. That is the direction. But here, Your Lordship, kindly come to page 42, Your Lordship. I may take your
So,
Lordship.
according to you, the agricultural company was entrusted the responsibility to pay the differential amount.
Yes, that is now by the appellate authorities order, appellate court's order.
Have you raised this point in the appeal that it is the responsibility of the bank to pay and
That
not
has
the
been from the very
agricultural?
beginning years. That has been continuing in
So
the
I am
appeal also.
asking you, sir,
Appeal.
did you raise this point before the division bench
Yes, yes,
that this is the responsibility of the bank
Bank
and
to
not
pay.
the agricultural company?
yes,
If you raise this point,
yes,
if the division bench has considered the sit point
yes,
and decided in one way or another,
yes.
then why the review?
My lord, the review is that
It is a conscious decision taken by the division bench.
this review is of the direction of the Honorable Apex Court, Your Lordship. We challenge this.
Sir, sir.
That's right. Your Lordship.
What was the direction?
Direction, my lord, your lordship, I will see. Page 7, your lordship, I will see.
The petition is
Repetition
dismissed.
that are challenged, way application was allowed in my favor.
Then
Yes,
the
that are dismissed.
petition was dismissed.
Dismissed. Against that, they had gone appeal, my lord, in Supreme Court, my lord.
Dismissal of the writ petition, they have gone.
Yes, my lord.
Oh,
That has gone.
That,
And I have filed the.
I'll explain. The tribunal's petitioner approached the state administrative tribunal. His original application was allowed. That was challenged by state before this honorable court in a writ petition.
Yes.
That,
I do not get a cost title. That's why I was thinking.
yes, yes. On page 9 is there.
Now,
And then what happened?
after
Apex court.
after dismissal of the writ petition for the division bench, we preferred SLP, and the SLP has been dismissed for not removing the defect, my lord.
Whatever
And-
the
and-
reason.
My lord,
What do you-
I admit that, my lord.
Yes,
The
that-
lordship may grant me a week's time so that it can be complied. My lord. Only that is what there has been some lapses because the matter was taken up along with 600 cases for non-removal of defect, and it has been dismissed. So that was not within the knowledge of the
This
authorities.
is from the state administrative tribunal.
Step, my lord, your lordship, page 9, your lordship, I will see.
The order passed by the state
Page 9,
administrative
state
tribunal.
administrative.
That is no more
Asking a very
function.
simple
Smile.
question. Why
Yes.
you are going here and
No,
there?
my lord. State administrative.
Oh. Now there is no state administrative tribunal.
No, that is it is no more functional right now.
It has been defunct.
Defunct by virtue of a notification. It has been defunct, and all the pending applications have been transferred to this honorable court and has been renumbered as writ petitions.
The Other methods.
Item number 3.
Oblige.
Lordship, the
Which
collector
order?
7010. Item 3.
Which order?
Order is in
Page.
Annexer 1, page 38. Wait.
You
There
are,
is specific, in
who are
order
you?
there is a specific direction.
Just wait. Who are you?
I am the petitioner person.
You, the petitioner is the partnership or a proprietorship?
Proprietorship
Are
concern.
you a proprietor?
I am a proprietor.
What was the direction passed?
Direction was passed in para 4, Your Lordship, to the collector Moyurvanj. So shall affording a reasonable
Anyhow,
opportunity.
a reasonable opportunity of hearing to you and other persons
Other
will be
persons.
interested and take a fresh decision
Yes.
within a time frame.
They given me this
Annexure 7.
opportunity. Just Your Lordship. They
Annexure
given me
7 is the
opportunity.
order.
Just let me understand. This order was passed on 14/7/2021.
Lordship.
Now, when a decision has been taken,
23 August 2021.
annexure
Annexure 7,
7.
page 46.
Maybe after 1 month.
Fifth paragraph, Your Lordship will find. Therefore, the petitioner noticed to appear in person before the opposite party to avail the opportunity of being heard on merit of his representation under Annexure 8 to the writ petition. As
So that's true. Upon hearing the examination of the report,
yes,
now the decision has been taken.
ma'am.
Yes.
The decision was taken. Lordship, kindly see para 4 of my writ petition. I was appeared on 16 August 2021. The submission was written. That is in Annexure 3 between collector and me.
So
Then after that, in 16th August 2021, one forgery false document was arrived to the collector. From forgery document, false document is arrived to the collector. Then collector make another inquiry upon that document after 12, after my appearance. Then inquiry has been in this. After that, they reject my petition particular based on that record which is coming after my appearance, and that is a false document.
no, where you have stated?
I stated in paragraph 4 of my writ petition. Sorry, contempt. Paragraph 4. Paragraph 6. Sorry, Lordship. Paragraph 6.
So this two letters were given to you. The inspection was given to you. You yourself have said.
No, Lordship. I had
What
not
are you
given.
talking about? You yourself have said.
I had given the document, this same document type.
That is whatever the 18 documents which you gave. And now, according to you, those 18 documents they have suppressed and they have not taken into consideration while taking a decision.
No, they are. What I am saying, Your Lordship, that in 16, kindly see what annexer I have annexed in flag D, annexer 13. Please, plus annexer 13, flag D.
Yes.
This is letter issued from the collector to the project administrator after my appearance of the collector.
True, maybe, but this letter, the copy of the letter was made known to you. You made an inspection when
That is made to PITD, not to me. That is made to PAITDA, not to the petitioner.
Or it may not be addressed to you, but at the time of the hearing, it was given to you.
No, not
You
time
had
of hearing.
Then
Not
how you got the copy of the letter?
that
You
is
have annexed.
that I got from RTI.
You come to your statement. You have said so. I'm reading from paragraph 5 onwards. You said on 12/8, the collector recorded your submissions. What
Right.
you have said, that is there.
Right.
Then on 16A, there is a letter which was issued with 2 numbers of enclosures, the Xerox copy, and then PADT searcher for verification is verified by me.
Verified by me at the time of inspection of the file by RTI.
Correct. So you were given an opportunity that these are the documents, you can verify it.
I verified that I found that
On
so mistake.
16/8, you were given an opportunity to verify under the RTI. It is
I
surprisingly
verified and I found that that is the false document and forgery document.
true.
They
So
should,
then you must have raised this objection at the time of hearing.
at the time of hearing, I don't know about, because my hearing is at 12/8. It was happened on 16/8 after 4 days.
Sir, the 16/8, you said that the letter has been given. The court has simply said that you give them a reasonable opportunity of hearing. That means that there should be a meaningful opportunity of hearing. You have given him. He appeared. Subsequently, you got some documents. Will you not give him a document? Will you not give them an opportunity to deal with those documents? And these documents could verified on the basis of an RTI reply.
In 24.
And that too in 2024. It was not made known to him. Then where is the reasonable opportunity of hearing which was directed by this court? You know the principles in a disciplinary proceeding also, that is ingrained. If you do not give them all the copies which you really want to rely in course of a proceeding, then it is a violation of the principle of natural justice. So this is not expected. The authorities will rely on, and these letters have been relied in the decision.
No. Yes, in decision.
Where is that? Show us that portion.
Order, the portion is on content petition page number 48.
Where is that?
In the second para, in view of the above, I am directing opinion that when the scripts submitted by the petitioner were not approved and the petitioner
No,
himself,
no, these two.
These two letters.
documents.
These
There
two
is the
documents.
letter of 16A.
16A,
Where is that reference?
their reference is not in that order.
So then if he has not taken into consideration, then where is the violation?
They are not taken into consideration. Lordship, kindly say annexure 13. Clear, it was clear.
Sir, simple thing. You are saying that these letters are unstamped, unsigned. It is a fabricated document. If this letter has not been taken into consideration, maybe something is there on record. It does not mean that the authority will take every document.
The letter subject was taken into consideration.
Where is that?
In paragraph 3 of page note 47 of the order, rejection order.
Was?
Paragraph 3.
Yes.
It is further disclosed from the record pursuant to supply order number so and so. The petitioner has submitted the scripts of Birsa Munda, Jaipal Singh, Dr. Lakho Burda, Tilka Maji,
Whatever. Yes.
Sorry. Vide letter number 519 dated 17/12/18. This is the letter.
What is that letter? That is not a letter.
Lordship, in 16/8 they got the letter number 519.
17. That is the 17th of December 2018 letter.
Yes.
Yes. So where is?
In letter number 16/8/21, that letter was found. Lordship, kindly see the letter number 1651 in annexure 13. Everything will be clear.
Annexure 13
of flag D. Documents filed with the affidavit.
Yes. What is this?
This is the letter which has
Where? Which page?
Page number 12.
Annexure D to the compliance affidavit.
No, Lordship, and flag D, the additional documents I filed.
It's flag C.
Flag D.
Flag B or
D for Delhi. Page number 12, annexure 13.
it is incorrectly stated as no, it's annexed to the compliance affidavit.
But he's relying on a 17/12/2018 letter. He's not. This is simply repository of what has happened earlier.
This letter was what, Lordship, when I appeared on 12/8, that was this event was not came. In 16/8, one event was came, that one letter I was issued into which came into notice of the collector in 2021.
That is the 17/12/2018 letters.
Yes, Lordship.
Now I'm talking about 17/12/2018 letter. Whether this was supplied to you before 12/8.
No, they were supplied, not supplied.
Where you have stated that it was not supplied, it was not given. Tell me.
Lordship, the letter number 519 is my letter is issued to collector.
True.
There are two letters in particular dispatch number, particular date number. One is original, which one I submitted. Another is fabricated, which is done from here.
Where is that fabricated letter?
The fabricated letter is that
which is your letter is what?
Lordship, in my contract petition, the fabricated letter is in annexure 5 and the original letter is in annexure 6. Contract petition. In page 43 fabricated, in page 45 original.
That is a 30th June 2019 letter. Page 45.
45 in content petition.
This is the 30th June.
Just a
minute. 43 is talking about.
He's saying
is a false.
Annexure 5. Annexure 5 is fraudulent document, Lordship.
True. Which one is correct? This is the 17/12. There must be a same letter of that same day.
Lordship.
Where is that?
Annexure 6 is a different letter.
You say which is
this is in page, Lordship, in page not 25-26 original letter of content petition.
Contempt 25, 26.
Page 25.
Contempt.
That is the writ petition portion. Earlier writ petition portion.
Yes.
What in same particular number?
We'll not.
Yeah,
We'll not
25,
go into
26 is original, which is issued by
whatever. There are two. If you look at the subject, there are two concepts. One is for letter of the script, and another is a letter for approval of the script. Those are two different concepts.
Approval of script is in 43, 45.
The 43, that's a genuine letter.
43 is fabricated.
No, 45 is 30th of June.
Your Lordship, the
Submission of the documentary film along with the DVD. No, sir.
43.
No, sir. Sorry, we don't.
Lordship, 43, 44 is fabricated letter. Kindly see Annexure 13. They wrote in that one letter from 1712.
If you are aggrieved, go and challenge before forum. It does not prevent you from challenging the forum, but contempt cannot be gone into this way. We are simply concentrating whether you have been given a reasonable opportunity of hearing or not. If we find that it has been given, whether the decision is correct or a decision is wrong, you have to challenge. Is a fresh cause of action. You go before the
Lordship, 1 minute, Lordship. The letter in page number 43, 44 was found by collector in 16/8/2021. They write on the letter in Annexure 13, Lordship.
This letter is still there. This letter is still there. If they found from the record that this letter is there,
Yes.
if you say it's a fabricated, it raises a very serious concern.
Fabricated, sir. Because the black and
You
white
will
letter
not,
in color.
sir, it appears your signature is there.
My signature, my
which
letter.
tallies with the signature of the others. Let them give the original. Let them come with that, and let us see whether there is any superimposition or not. These are the matters. The contempt court will not go and make a roving inquiry. You go to the other forum.
Liberty can be
another
challenge the
aspect
order. Challenge the order.
And another aspect, the order passed in 2021. That was compliant. Maybe as per him, it may be a wrong compliance. But the contempt petition has been filed in 2024 after 3 years. Whether it is maintainable, if the lordship subject to my lords.
He has been very interestingly and very intelligently done it. He says that this fraud or something came in my knowledge in 2024 when he received the information under RTI, and 1 year period will start from the day when the
Knowledge.
Section 20.
Was the rejection order not communicated to him?
Was it communicated to him?
Then you made inquiry after
They
3
made
years.
the inquiry. Where this letter come? I then made inquiry.
When this was communicated to you, 2021?
21.
And then you were waiting for 3
No,
years
Lordship, honestly, Lordship, I was admitted in hospital surgery in
for
22.
3 years.
No, for 1 year. After second
1
COVID.
year,
1 year,
surgery.
Lordship, I have annexed the documents in Annexure 20 of the documents, Lordship. I hospitalized. Or because I was unable to sleep for up to 6 months after second COVID. Then one surgery has done my sleep apnea. The doctor advised me to take at least 12 months rest. After that, I am unable to see some deposit in my eye on the record, Lordship. Then doctor tell don't take any stress. I have not taken any stress. Now I'm eligible to see.
The
Item number 4.
Yeah, please, Your Lordship. Lordship, there is the review petition filed by the petitioner. A judgment delivered on dated 21/1/2025 under Annexure 1, Your Lordship, in WBC number 30756 of 2024.
Yes.
Lordship, there are such ground, Your Lordship. First of all, this is not case of transfer. This is case of absorption. And thereafter, Your Lordship, the judgment which has been relied upon, that Silpi Bose, is not totally applicable to this matter, Your Lordship.
Can it be gone into a review? Show me one judgment, I will be happy.
Your Lordship,
You are really you are trying to re-hear or re-argue the matter. The court has wrongly applied this judgment. The court has wrongly applied this paragraph. These are all a re-argument which has been done, which is not a subject matter of a review.
on the very threshold, this matter has been dismissed by the division.
Whatever that can be, is there any law says that you cannot dismiss any matter
No, Your
on
Lordship.
the threshold?
On the ground that is erroneous, Your Lordship. Therefore,
erroneous decision is something else than a decision containing the error apparent on the face of the record. Erroneous decision, you go before the higher up. But
Your Lordship, why it needs
my own judgments are there. Distinction based upon a Supreme Court judgment way back in Tungabhadra.
You have to bring it within the parameters of
Have you
review.
read the Tungabhadra's judgment of the Supreme Court?
No, Lordship.
Read that, the scope of the review. Rupa Ashok Pura, you read. Can't be. Review cannot be stressed. And they have recorded in paragraph 10 the absorption and all, everything has been recorded.
Lordship, but that is the absorption. This is not a transfer, Lordship.
So whatever.
And the option which has been provided to the petitioner, Lordship, the posting has been done, Your Lordship.
In page 12, we have recorded that the application filed by the petitioner reveals the prayer was made to pause the order of absorption of the petitioner is RMS and division and for direction to absorb in the post of post assistant. And the court has thereafter decided.
But
so it's an erroneous decision.
But relied upon that decision of transfer, Your Lordship. This is not a case of transfer, Your Lordship. It's a case of absorption, Your Lordship. As because
it was two twin prayer. One is absorption. You are challenging the absorption to the post of user.
Yes, Your Lordship.
And you wanted an absorption in a postal assistant.
In circle office, Your Lordship.
Or in circle office. The court, and you have been directed to be posted in that RMS and division.
Yes, Your Lordship.
Absorption was made.
Absorption was made wrongly, Your Lordship.
What?
That is my prayer, Your Lordship.
Do one thing. Who's for? We are reviewing it and then dismissing, and the order of absorption goes. And let him remain. There will be any absorption.
Lordship.
He remain a contractual employee.
No, Your Lordship.
So after order of absorption goes, what will happen? What will be the status?
Your Lordship, may I
I'm asking you, sir. What will be your status after absorption? Order goes.
Your Lordship, this absorption has made due to closure of that postal printing press, Your Lordship. Due to closure
exactly, Miss. That is why it is asked. Once that order goes, where will you be?
Try to understand. The court has been very, 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 and they have shown, I think, some benevolent.
Reason they have assigned that due to lack of administrative knowledge.
Nothing. Did you write a? Let's review again. Not again. The very extensive judgment.
The actual error
apparent on the face of record.
Oh,
That will
you were trying a parity with 63 candidates.
not even that.
Not
That is one limb of the submission, but subsequent. But kindly see para 13. That will I think that will settle our case. After careful, may I please, may
Yes.
35, page 35.
Yes.
After carefully hearing in paragraph 13, after carefully hearing the loan counsel and going through the records and the decision of Supreme Court, we are not convinced to the submission advanced on behalf of the appellants, who are the appellants, that the state was under obligation to fill up all the vacancies existing prior to 31.
It says that you do not belong to the ST and SC category.
Yes, but we SCs were available. That's the present appellants.
Sir, the question is that the positive finding is that you do not belong to ST and SC.
No, no SC/ST candidates are available. But we SC/ST are available. That is they are the appellants.
Sir, question is, you are referring paragraph 13.
My lord.
Please come to the last two lines.
Yes.
At the bottom. What it says.
Well, the appellants do not belong to SC and ST, but
that is what I'm saying.
Yes.
That you do not belong to ST/ST category, STS category. Now, at page 41, paragraph 17, which is the ultimate decision. You wanted a parity with 63 other candidates. The court has said that you can't because they belong to ST category.
Even my lord,
So you can't. They are a distinct class by itself.
My humble submission for my lord that the present appellants are SC categories. They are
Where do you say
Because
the positive finding of the court is that you do not belong.
But the fact remains, the list which are under challenge, we belong to that requisition is with the government. The panel is with the government. And government advocate says they are not the SC/ST.
Sir, please, what are the records or what are the documents on the record which would say that you belong to SC/ST category and this finding is wrong?
The panel
show us from the writ petition, the document, any one document which would throw light on that.
My lord, kindly, may I submit my lord one aspect? The present appellants.
Sir, I am asking you a very specific question.
Yes.
The court has arrived at the positive finding that you do not belong to SC/ST category. That according to you is wrong. Show us that what document was there in the writ petition which would prove that you belong to SC/ST category. Simple question.
This finding of the Honorable Court was on the basis of submission of the government report. Now that is correct, my lord. So
no, that is why you show us that submission was wrong from some document you show us, which was there on record.
If I permitted, then there is a panel, my lord. Kindly bear mercy on me. The panel
was that panel
includes us.
Please show us that this panel was included in the writ petition. There you have been shown in an SC/ST category. Everything you are considered. Show us the document I want.
But is it not
when you know the scope of review?
My lord, I am conscious of the review. Patent error. Why I submit patent error?
Patent error what?
But it's factual error.
No.
One SC/ST
no, sir. No, sir. I think this is a half-baked argument. Not a patent error. The error which is patent on the record. What is the meaning of the word on the record? Under Order 47, Rule 1 of the Code of Procedure.
Any sufficient reason, my lord?
What?
Sufficient reason means we are available.
What sufficient reason?
SC candidates are available in the panel.
Sir, I am conscious. Are you aware of those line of judgment where other sufficient reason must be linked with the others?
Discovery of facts
discovery of new and important materials which were not known to you despite due diligence.
Yes.
Now you show me that where you have found due diligence. Show us from the facts. Sir, what you are referring?
That is that post remand vacant for SCSP for SC.
Sir,
But I understand.
here having
I
one
understand.
document in the pocket is not sufficient. When the statute says due diligence, then you will have to discharge the due diligence concept.
Then my lord, read appeal that must be there. I will take one data test because scheduled. Why I say scheduled caste candidates are available in the panel. State says that there is no scheduled caste tribe for candidates available, and we are the candidates.
I do not want to go into this.
Now, whether such a pleading is there, I'll minute scrutiny will be there. One minute scrutiny because it will go against minimum 17 and 19 candidates. Panel is there.
Sir,
Government knows.
Come with the judgment. I am on that.
Judgment is
Shows that the court will reopen the entire issue.
not reopen. No.
Not
not going to
will
reopen.
rewrite the judgment again.
I am obliged for the knowledge. But question is that we have to show in the writ appeal what is that contention is there.
I am asking you, sir, when
Reiterate appeal.
do you think that the procedure which is available in the Indian judicial parlance, that the judge while writing a judgment shall not use any word which is not there in the plea?
Yes.
That is what you say.
What I humbly
Or the judgment is independent. It is a pure prerogative of the judge how to write a judgment, how to use the word.
My lord, what I humbly submit, kindly allows only that whether there is a specific pleading, what my lord has already said, is there in the writ or writ appeal. That is the only point I have. Otherwise, my lord has already enlarged the scope and has given us the pointed. When
Sir,
no,
you did not. You are arguing engaged for a review.
review only.
Advocate and record
For-
was there.
He is not available. Advocate
Who has filed this?
review application. So myself has appeared, but
He was not in the appeal.
no, both the apply.
You were not there.
No.
Please read the another Supreme Court judgment, AIR 1997 Supreme Court, page 1005. It's a technical one, whether you can appear or he can appear.
No, I'm on notice. I'm appearing for the opposite party.
Whether
Opposite party.
he is opposite. You can appear. Please read the judgment. Supreme Court, in a very strong words, have deprecated this of.
Yes. I'll go through it, but he
Go through it. Don't argue.
No, my lord asked about his locus standi.
No. I
He
just
was
thought
along
he's
with us.
leaving. He's appearing with you. I just thought that he's assisting you.
No. He's also a co-applicant.
Whatever. I am talking about you. 97 Supreme Court is here. Give it to him. Give it to him. Read 97 Supreme Court. A small judgment, particularly paragraph 1 or 2, sufficient for you.
But he was asking.
Sufficient for you.
This candidate, this present
I am
appellants
talking
were
about you.
Can it be only one day? 7 days
You
after?
just go through it.
I'll go through it.
Just
I'll go through it.
giving you an opportunity to go through it.
But the question is that
Here,
here, my lord, what a
Question is that judgment.
Supreme Court, scheduled caste candidates are available.
Question is that
But
judgment.
because there is no scheduled caste persons in the panel.
Sir,
in
the
case.
Supreme Court in that judgment says that the court will not permit any litigant to engage the lawyer who did not argue the main matter, but to argue a review and then reopen. The Supreme Court has deprecated cost in 1997 was 20,000. So now we are in 2025. I think 28 years have, or 2026, 28 years have gone.
From Delhi. So
Please
he was
give
honorable.
us-
That is the reason
give
I
him
appear.
1005, I believe so.
Here the case is different, my lord. The concerned advocate is from Delhi.
Sir,
He
without reading the judgment.
No,
You
why
are a
should I-
very seasoned
why should I
advocate.
disbelieve my lord? My lord says, I will go by that. I will not even
Then you
go.
can't appear.
They can't.
After 28 years, what should be the cost?
But Rajiv, mostly different occasions, different realities. The person
What
concerned
is the
advocate
different
was not
occasion
well.
reality?
Come with him.
No. Here the question is, were you there when the matters were
No,
argued?
that honestly say I didn't
So
argue.
that is the point in that case.
What
So-
my lord, I was arguing.
No, we are not saying that you are arguing it without taking consent or anything. You can, but Supreme Court has said if you were not there,
Not consent.
how do you know? How do you
He's
know?
there. He's
No.
there. The fan. He's
How do you know what was argued?
Oh, then we will take up next matter. We have another bench yet. This may be on a 10 days, after 10 days.
10 days you are very much.
13th of February is okay. So it's good. Go through that judgment.
Yes, yes.
One more.
My lord, this is non-compliance of the orders of this.
Which is the order? Can you show us the order?
This order was passed on 6th
Compensation with interest.
July 20th. Page number 21. My lord. This was
2
communicated.
months.
Oh.
Yes.
Milord,
That was 2022. When you have filed, sir.
By order, this
No, but the contempt, sir.
24, Milord. 1/8/2024.
Beyond 1 year,
Not maintaining.
not maintainable. Section 20 comes into play.
this was communicated, my lord.
Sir, I am asking you, this has been done.
The second one is maintainable. You had earlier filed a writ content petition. The second content you have filed, but in the past case, no earlier content was filed. It is beyond period of limitation, so it cannot be entertained.
This was
Pallab Seth's judgment of the Supreme Court, sir. It says
And,
that Section 20 has to be activated.
and
Have
item
you
number
seen-
1 and 2 are similar.
Have you got the Pallab Seth judgment?
Yes.
I think Justice Rumapal was one of the member of the bench.
Subsequent judgment also.
Subsequent.
Tirupati Rao, 2024.
That is the setting loss.
First time the Pallab Seth judgment is the first judgment
That has been.
on
Para-
limitation.
Let's see, paragraph 53. Paragraph 53 and 54. Milord.
No, this is the 24 judgment. Where is the earlier judgment?
Milord, Pallab said, take a note of it. And paragraph 54. 53 and 54. Milord.
So what to do? Yes, Pallab Seth has been taken care of.
53. Milord.
Not within a year. And not beyond.
Sir, what to do? Can't be.
Please consider this.
We can't go beyond the law. Can we go?
What is problems?
Have you taken a decision? Compensation and all?
They're about to take a decision because
In the connected matter, also the matter issue is same.
yes,
He has taken appropriate step in the connected matter.
Yes.
But in the past case, he cannot file.
It has to go, sir. A preliminary objection is raised by the counsel appear
This is
Same, sir.
I will find a contract within time.
In this matter, my lord, government has taken a decision, my lord, to pay 15,47,000 to the petitioner. We will file an affidavit.
File an affidavit. Pay.
So where is the distance? So
Yes, my lord. Only
Pay.
they have got an instruction.
they have already got a
Yes.
We are keeping this matter after fortnight. In the meantime,
Yes.
pay.
Yes.
It is.
Item number 3.
Item number 3, Your Lordship.
What is the direction pass?
Lordship, at page 8, the relevant order, Your Lordship. The direction is at para 2 of the order, page number 10.
Have you filed a review?
The review, we are in the process of filing the review.
What is the process?
But
The order was passed way back more than 1 year. It's still in the process of review.
I don't happy, sir.
Here
You
also,
got not enter.
here also my learned friend has filed an application for condonation of delay. My lord.
That is not
There is a
maintainable.
delay of 1
I will not praise that particular IA because I know that condonation delay will not be maintainable for a contempt petition.
Why you know?
That will not be maintainable.
Not.
Will not.
Don't you have any judgment in your kitty?
Probably I found otherwise.
Yes. Comply.
So review we will.
You have to comply, Mr. Das. You do not file a place of the liberty granted by the Appeals Court.
For more than 1.5 years. July. Now we are in the back end of the January 2026.
But there is already a proposal. We'll
What
file.
proposal?
We have received the proposal.
No, sir.
We'll file the review.
No, sir.
So in the matter listed, you are taking that plea.
No. This cannot be done. Cannot be done.
Also,
You have to comply or we have to issue some directions.
may grant 2 weeks time.
No 2 weeks.
2 weeks time may be granted so that
For compliance, not to file a review. On merit also, Appeals Court did not interfere. Only granted you liberty to file a
liberty
review.
to file the
They have not filed it.
that voting
Very
there.
interesting ground was taken that the writ petition was disposed of on the day when it was
Listed.
listed. Why not? The Supreme Court has said nothing doing. If there is no merit, court can dismiss it unnecessarily. Why the court will keep it pending? The direction was with this matter, Anand Das. No, the direction is that it will be applicable in this case. Yes. Now you are in contempt. We cannot be a mute spectator. As per your leisure time, you take a decision whether to come after 5 years.
So
But
that's
contempt is pending.
Even if you file a review, it will be bad by time also. It will be dismissed ultimately. Because it 1.5 hour in 1.5 hour delay. There is no meaning in review now also.
Let's see, understand my. But I'll.
No, file a complaint. File a complaint.
I understand. No difficulty. We are recording.
I'm sorry.
We are recording.
Lordship,
Don't worry.
grant me 2 weeks time.
We are
So that
granting
I
you
in the
2 weeks
meantime
time, but we are recording something.
I'll take.
We should record so that at least yes. The
Item 4,
Of which order, sir?
the order dated 13/12/2020.
Mr. Mishra, on the last occasion, my lord has raised a point whether the review is reasonable because of order 47 rule 1. Because basically on a subsequent order, you are filing the review.
Yes,
Whether it is maintainable.
So,
And there is a direct decision of the appeals court also which goes against you.
that was the query of your lordships.
Yes,
So,
sir.
may I humbly submit, my lord, since I had filed a writ petition and subsequently filed an application for recalling of that order, and after the order was passed by this honorable court in the divisional bench, I have filed this present review petition on annexure 15, my lord. And with that, may I permitted to agitate the grievance before the honorable.
Go there. Yeah, we are not making any.
No. Why I am submitting? Because initially I filed a writ petition. It was not written, so that's why I am seeking liberty, my lord.
What liberty?
Liberty.
It's open. We are simply withdrawing it with an observations that withdrawal will not stand in the
My
way.
lord, my lord.
So, the counsel for the petitioner submits.
Item 5, they filed a
My
IA
lord.
89 of 2005 just now. So,
What IA?
My lord, because during pendency of the contempt petition, they have rejected our prayer for my lord, for compassionate appointment.
For IA,
Order,
for this the IA to what?
my lord, only to bring it to your lordship's notice because this is also contemptuous of the alleged contempt.
The order that they cannot reject the application.
My lord, may kindly see this honorable court directed that my case is covered to the decision of honorable apex court in case of Malayanandi Sethi versus state of Odisha and consider the case of the petitioner according to Malayananda Sethi case.
Correct.
But they have not misinterpreted the order passed by this honorable court and they have given another order of honorable apex court and rejected my prayer.
So if this
that I
am just asking,
my lord,
if the Malayananda Sethi's judgment of the apex court
my lord,
is rendered by a higher quorum of the Supreme Court to be a bad law or not a good law, then are they bound to
no, my lord, that has not been decided.
I do not know under
but now the government has come up with a new notification. You challenge that press order, taking recourse to that new notification will get the benefit. Why are pressing this contempt? Because my lord, since 2001, you have to challenge that rejection. Challenge that rejection by filing a writ petition, press writ petition. It can be decided. Now government has framed a new set of rules. My lord, again I have to go to tribunal. Go there. Then, my lord,
what? Is a tribunal under Article 323A?
My lord. Move there.
Go there.
My lord, give me liberty.
Have they applied the judgment of the Supreme Court in Himaya?
My lord, my kind see
what judgment you applied?
My lord, that is State of West Bengal versus Debabrata Tiwari.
Of which
civil appeal number 8842.
I'm afraid which
that is 3/3/2023.
3/3/23.
Better not to place the judgment. Maybe there is a possibility.
Have you got that order? No. then come prepared with that order on the next date.
My lord.
Judgment.
My lord, I have not seen.
Please look at
So, yes, I will go through it. Perhaps, my lord.
may not be.
My lord.
May not be. Keeping it after 2 weeks.
Yes, my lord.
You come prepared with that judgment.
Yes, yes.
Item number 6.
Let the last order date is 15/9/2025. Your lordship have granted them time on their prayer for compliance.
12/9.
12/9.
12/9/2020.
Yes, sir. Sir. Where is Mr. Das? You appeared.
No, my lord, today morning I have taken the instruction.
Oh,
He's providing the
letter, authentic letter.
Let them survey copy. I will take
Giving
instruction.
you letter of appointment is
It has not been served on me.
On 29/1.
7 days time is given to you to join.
It is complete, Mr.
Yes, ma'am. Yes, madam. In that event, your lord.
It has already go and join.
Yeah, well, because today morning at 10,
On that basis, disposable. You have been blessed with the service. Don't appointment.
Be happy with that.
okay.
May I please? The second contempt application.
Oh, second. How available?
My lord, this honorable court directed earlier on Lakshmi, kindly see.
How the second content application lies?
Lord, previously that liberty.
What? Can the court touch the original order
Lakshmi,
in
kindly.
a contempt jurisdiction? Tell me under the Contempt of Courts Act whether it provides for a second contempt.
Lord, that the order of your lordship, this honorable court's order has not been complied with till today. But that order has passed on 29/1/2023.
9/1/2023, page 13, your lordship.
Yes.
And this contempt petition is filed, my lord, on 26/5/2025.
Well, thereafter,
So
thereafter I filed another application, contempt application on 18/1/2024.
yes.
The order is at page 19, your lordship.
5/2/2024.
19, page 19.
When the first contempt was filed?
The first contempt was filed, my lord, that was disposed of on
Within time, your lordship.
page
Within time,
19.
your lordship. That 18/1/2024.
Yes.
And disposed of on 5
That was disposed of on 5/2/2024.
3 months time was given for so or will you not?
But I have to file an affidavit, my lord, in this matter. For the first time it is coming, my lord.
First time, what is?
Yes.
File your affidavit. Plea of limitation cannot arise because there is a further direction on 5/2.
Yes.
So if that order is also not complied with, the attempt is within the jurisdiction, within the time. Is the council
Item number 2.
Item number 2 may I plead, my lord. Challenging the illegal demand raised in favor of the petitioner
Illegal demand.
for conversion fees, petitioner has approached this honorable court, and this honorable court under Annexure 1
13, Milord, page 13.
page 14 is the operating portion of the order, my lord.
Page 15.
Yes, my lord, page 15. The impugned demand is
Additional land officer will forthwith issue demand for conversion fees on the basis of that order of 22nd February.
yes, my lord.
Within 3 weeks.
Demand has to be raised within 3 weeks, and the complaints has to be made within 30 days.
Within 30 days.
That order reviewed under Annexure 6, my lord, and that's was dismissed by the honorable court. Again, approaching
on 20. Have they done it?
No, my lord, they have not done.
Demand for conversion? Why?
Even after dismissal of the honorable Supreme Court.
Why it is not done?
Milord, I have received instruction in this matter, Milord, today, and it is already done.
Done?
Yes. And the conversion fee he has to pay, that is amounting to rupees 16,42,500 only.
I pray for a copy of that letter.
It is submitted by the council appearing for the res contemptor.
Obligation.
Item number
You
3.
comply in the meantime, see, and then
Obligation.
Item 3.
who is appearing? There was a direction. Reinstatement of the petitioner to other contractors.
Milord, state is not the party here, Milord.
Then who is the party?
Milord, manager HR IFCO.
Who is the contemner?
Notice is to go, Milord. IFCO Paradip.
Oh, then why you are appearing?
No, Milord, we are not appealing.
Notice. 3 weeks. Requisites within 1 week from date.
Item 4, same, Milord. Same party.
Yes, same party.
Same party.
Yes. Notice.
Item number 5.
Milord, here let's kindly see flag A, Milord. They have filed an IA for withdrawal of the review application.
IA for?
Withdrawal of the review application.
You want to?
No, Milord.
Oh, you want to withdraw?
Yes, ma'am.
Yes. The council for the
My lord, I am for the petitioner here, my lord. The
My brother's order is not complied with.
my lord, my lord has interfered. For that, the people are got some light after this order. After the order in the review.
Which is the order?
My lord, the order is at
16.
21 September.
Page
16 it starts, Malad.
and
And the relevant portion
is
page 20, Malad, para 9.
Para 9 is the order.
What you have done? You have not completed by
My lords, now may kindly have a glance at my lord's order passed on 20th of June. My lord, in this contempt case, 20th of June 2025. There, my lords, on 20th of June, my lords, considering the enormity, my lords, and the volume of petitions, my lord, we have stated before, my lords, that we have received 1,435 applications. Out of which 90 cases
this was a Rath Yatra exercise that was
my lords had allowed.
But now it has.
Yes, my lords had permitted 3 months' time. Now 6 months has elapsed. But, my lords, substantial progress has been made. In fact, all these applications have been inquired into, my lords, and the reports have been submitted. Thereafter, my lord, the forest officer, my lord, the opportunity of hearing was given to all the applicants, my lord. All of them were heard, my lords. Now, my lords, after that hearing has been concluded, and now, my lords, as per the Wildlife Reservation Act, my lords, 3 options are there under Section 24 under the Wildlife Protection Act. My lords,
whatever, the court has not opined anything.
Yes, my lords.
The court has said when has fixed a deadline within which everything is to be done. Will you not do
yes,
that?
My lords.
We have been very liberal.
My lords have been very liberal.
There, but that cannot be taken as a premium.
My lords.
To continue with this exercise for all time to come.
My lords, we are
the order was passed as far back as on 21st of September. Now 2023. Now we have more than 2 years have elapsed.
Yes, my lords.
We can't sit eternally for all time to come. That there's once some concession was given to you, you take it as a bonanza for all time to come. Sorry, we can't accept it.
Now, we are the last.
Sorry, we can't do it. We'll have to, otherwise we are issuing a notice. We are issuing a notice. We are issuing a rule. Then why I should not?
My lords, kindly have the instruction. My lords,
sorry, we can't. This is not a way. This is not a writ petition, sir. You are in a contempt.
Yes, my lords.
Your every action is being tested on the envelope of that particular direction.
There has been delay, my lords, are bowed down. But
so,
lords, considering the
are you aware of the Supreme Court judgment of 2012 of a 3-judge bench, which says that a delay, dormant, and lethargic in complying the order is a contemptuous act?
Yes, my lords, I bow down.
What more?
I admit, my lord, there is
sorry,
delay.
We can't.
I admit.
Then let you face. Let you face the consequences.
My lord, the enormity of the exercise.
June, we gave you some. We were liberal because of the Rath Yatra being there.
But my lord, after
that does not mean
we have made, my lord, there.
What? In July, August, September, October, November, December. Now January is gone.
But my lord, there is a
more than 7 months have gone.
My lord, there is a process that we have to follow.
Sorry,
my lord, we have left no stone unturned. My lord,
no, sir. It does not appear to us. Your conduct does not instill a confidence in us that you have been doing it with all commitments.
Yes,
sorry, you just wanted to do a dilly dolly things and all everything.
Filed by 1,400 persons, my lord, they were verified physically.
Every time some instruction.
My lord,
convince the judge. You could have convinced the bench on that day that 3 months time is too short for this.
Yes.
The bench should have given you more time.
Yes, my lord, that.
You did not.
We asked for 3 months and my lord.
Sorry, then.
But my lord,
no, sir.
My lord, after that,
how many 3 months have already elapsed?
My lord, totally correct. I totally bow down.
And this kind of exercise in a contempt is not acceptable.
After that, 1,500 persons were heard in person. Opportunity.
Whatever, sir. Whatever you have all the infrastructures. You have all the manpower. You have everything with you. Sorry, process is not cumbersome or so complicated.
It also.
What are you talking about?
Volume of petitions received.
Nothing. The volume of petitions.
That is
that cannot be done.
And now, my lords, we have the last. Like, my lords, may see the last paragraph.
There was no inquiry till my lords passed the order.
Yes.
Then after passing the order,
Is it true what they are saying even as on date that all these 1400 applications have been heard?
my lord, that information I don't have because they are
last time
they
you
are
said that only 90 applications were heard.
90.
Now,
That information I have. That 90. Thereafter, what has
because again
happened?
they will come that many of the applications have not been heard.
Not been
Is it
heard,
correct?
my lord. That is
All
right.
of them have been heard. They are after heard in person, my lord. They were called and heard in person. Now, my lord, may say, I have given the letter issued to the, my lord, so under the Wildlife Protection Act to the forest warden. There is a statutory provision, my lords, you see. My lords, section 24 of the Wildlife Protection Act, there is a statutory provision, my lords. Either the government can acquire the property.
No, that plea you could have taken, as my lord is saying, at the very initiation of
My
the
lord,
attempt.
my lord, the entire process should have been completed within 2 years from 1987. And in 2023, my lords have passed the order. Still 2 years already elapsed.
In 23, my lord, we were given time up till December 2024. Yes, my lord.
And people are not able to use their land, my lord.
No, I totally.
Sir, it was a 3 months time which was given.
Yes, my lord. My lord had been, my lord, pleased to grant 3 months time, my lord. We have
No,
utilized it to the
that
fullest.
was the original order. But still, when you came and take a very sentimental or religious plea that because of the Rath Yatra, which we also know is a very pious and a very important festival of the state, we simply say that yes, all your officers are engaged there. We can appreciate it. Do it. But that does not mean that we have given you a complete.
No, my lords. No, my lords. But, my lords, we are also informed this honorable court, my lords, may see the first paragraph that 1,430.
I may be permitted to, my lord, correct, my lord.
Why?
Because
At
in the
dean you are giving them
my lord, my lord.
Item
Petition for condonation of delay not raised.
Why?
This has come for the first time.
Pardon?
First time listing. So notice has to go in the limitation matter.
No, limitation not at all necessary. So that is, I'm not pressing that petition.
No, you have filed an IA seeking condemnation of the delay.
Yes, ma'am.
So without notice, how can that be considered? You are appearing, you are not India. So you are taking notice, accepting notice. Want to file objection?
How much days delay?
48 days.
48 days.
What do you say? On a delay? Have you got the application?
My lords. On the ground of delay application.
To Gaurav.
Look at his time.
Well, as per noting, it has been mentioned relay is extensive, but the higher number certain something.
The material to show that the date of an account of negligence to total draft. No negligence has to be.
No, the file is not traceable in my team.
Not traceable. Mulur upon Koivana, you should have told that from the beginning.
Yes.
As suggested by my lord, we will be condoning the delay subject to cost. We will hear it on merits. 48 days delay.
Yes.
On the next day, we will dispose of.
Yes.
So both of you come prepared.
Yes.
That's a small matter.
But
This is an application.
if my learned friend serve the copy of the writ petition because
When do you want?
any day is my lord will.
Today you said the file is missing. The next day you will say
Oh, my lord.
you are in difficulty.
Not that.
So after exhausting all those, you give us a clear date on which date it can be disposed of.
In the month of March last week.
2027?
Yes, my lord will fix it.
No. 27. 27 February, sorry. Friday. Friday. 27 February.
No.
Come prepared.
Only one request of my friend that because after long period is come, copy of the read petition.
A copy of the review petition as well as the read petition you saw.
Orders item number 1.
My lord, I may be permitted to withdraw because the orders have been already been complied with.
Other side. Nobody. Go.
Item number 2.
May I please, your lordship? My lord, I'm in BC, my lord. Non-compliance of order dated 2/8/2022 in publication 521.
It has already been complied with.
He has been observed with effect from 1997, and the period of service rendered from 1997 till 2008. Since he did not work for that period, he is not entitled to the financial benefit in terms of
But
the order.
notional benefit you have given from 1997.
Yes.
So what more?
My lord, a copy may be.
Your lordship, the direction. It is at page
Second contempt.
That I will not say anything else.
Yes, sir.
So lordship may
This one second.
only see para 9 for the aforementioned.
Where is the order? I have
But
not
the order
Annexure 1.
Annexure 1, page 15, your lordship may the operative portion.
15.
Page 15, the operative portion, para 9. For the aforementioned reason.
Set aside for absorption.
Absorption in terms of so and so within a period of 4 weeks.
So
from
that you have already done.
Yes.
And given a notional benefit. Yes, sir. If
So
you are aggrieved, if you are still aggrieved, then you should be given a full financial benefit. Then it's a fresh cause of action. Go
Yes,
there.
my lord. Yes, cause of action, I will challenge it, my lord.
Oh, that is up to you.
Yes, my lord.
Look.
May I mention a ARP pin?
Old matters are coming.
Old matter item number 1.
Who is appearing?
Item number 1, MSA 24 of 2002.
Dismiss.
Item number 2.
Dismiss.
Special mission item number 3, RBP 54 of 2025.
Yes.
But here the arbitration clause is page 25.
Page
25. Clause 25.
Page
25, clause 25.
Still for first time.
Toward
I will take him.
every matter has a first time.
In this case, as it was listed earlier, I
This
have
was
copy.
served upon software.
Copy counter ready? Yes, sir. Sorry, my lord. We have ready with the counter like officer for June. Great. What's up with
What? Are you taking a plea of maintainability?
we are taking the
We can't adjudicate. We simply say that the dispute has arisen. If they have asserted something and you have denied, then the dispute arises. And if the oral has been provided, then you'll have to go and fight it on merit. Go through the counter. Where file it.
already today on filing or copy also have to other side.
Where is the file? Give. File.
Yes.
Let the counter affidavit filed by the interested party be written on the top.
Item number 4.
Again this. Again this.
Item number 4.
Another PS report. Adjourn for 2 weeks.
Item number 5.
My lord, in this case, we have received instruction 1 week to file the reply.
Yes, sir. Why in a section 11 application? If you have the objection, you can place it. These are all the technical objections which are to be taken. Factually, what we are not going to adjudicate. The court is not adjudicating the dispute. The court is ascertaining whether there is a dispute.
Yes.
And this dispute is within the arbitration clause. Ultimate decision will be taken by the arbitrator to go on merit. No objection.
Let it come next week. Mr. Tripathi was doing matter. He
Whatever.
engaged somewhere.
It's not a
He asked me to do it. Next week.
Item number 6.
It is your option. Sir, Fresh matter, my lord.
Where is the arbitration clause?
Well, the arbitration clause, your lordship, may I kindly have, my lord, clause 64 at page 139. But before that, your lordship may also see clause 63 because it's an escalating clause, my lord. 63 provides for conciliation.
Page 139 clause.
64.1, my lord, demand for arbitration.
Yes, where is the clause 63.1?
My lord, this is just the previous page, my lord. 138.
What is your stand? Does it come under the accepted matters?
It is listed first time at Annexure 15, page 257. There is a dispute claims arising out of this such and such dated 19/10/2020, and his amount is 10,64,000 some odd. Contractor, he stated so. That's why the railway asks the requester to kindly share this draft supplementary agreement, all these things. That part, whether it is this subsequent agreement is there or not, or I've taken instruction or
Not subsequent agreement. How can there be a subsequent agreement?
because this letter this lordship see the letter the movement request to kindly share the draft supplementary agreement. That means with the continuing the term of condition. That means page 257 is the letter of from the concerned party, the deputy chief engineer. GM administration put a letter to them. After 10 days, any date lordship fix. 3 points has been raised by the.
But this is in relation to an appointment of an arbitrator from the Indian Council of Arbitration.
No, my lord, that is why, my lord, may I only clarify, my lord. My lord, here, my lord, I'll clarify, my lord. My lord, may kindly have page 241. When I send them an arbitration notice, they said, we will not accept your arbitration notice. Please enter into a supplementary agreement with us where we decide who your arbitrator would be. My lord, may kindly have 240.
That is opposed to
I completely
judgment of the Supreme Court.
My lord, core judgment, my lord. That is exactly my case. That has already been. So, my lord.
So how can you?
Exactly. And number two, my lord,
power has been taken away by the Supreme Court. Says you can't do it.
And they are saying, please enter into a supplementary lead. Yeah,
so will not enter.
So the dispute is there.
And my lord, to clarify your lordship's query, there is a series of communication. No communication they have said it is coming under 63(1).
That is
exempted matters.
Wanted the accepted matters, no, whether it comes.
None of the communication they have raised that point. The only point is that listen, you enter into an agreement, we will decide. We said we will not decide. We will not go by that. So to clarify my
what more, sir?
10 days, only 10 days. Because the first time it has come, I don't have any.
So what?
They serve the copy basing on that. I am just submitting, my lord.
So
only one that
they like that.
Plus, fixing that
on the prayer of the DSG.
My lord will fix to 30.
Fortnight. After 15 days.
Item note 7.
Do we finally decide, my lord, if your lordship?
Has to be.
Deeply obliged. Great.
That point,
thank you. May I please, Lord? It's the same railway contract, my lord. Page 177. That's
first time.
Is first time.
Here there is a reply to my invocation letter. There is a reply, my lord, to my invocation letter. So their stand is, they made their stand.
Ask him what he will say.
Here, my lord, they say unless the clause says ki railway officials to be appointed. So you first waive the applicability of that, then we will appoint. Otherwise, we will not. That's their stand, my lord. Page 187 is their reply to my invocation.
282.
282, annexure 10. Yes.
How can
That
you?
seems correct.
How can you say?
Huh? I've seen that. But you also keep the same day after 10 days anyway. I've seen
There
that.
are some of the open and shut cases which does not require any.
What happened, my lord? All the cases I've seen, this old agreement, even though it was amended 2015,
Maybe the
they're
latest
continuing
law,
that agreement.
the
This is
latest
the whole
law-
problem for.
The latest law is this.
Yes.
I think I delivered a judgment.
Yes, your lord.
My lord also.
Yes. Sitting here.
Yes. I have gone to it.
Yes.
Item number 8.
Officials are neither understand the law nor they are going to the judgment of the courts. Only they are acted according to their own.
Well, this second appeal compromise petition has been filed and my senior friend is appearing through Rishi.
I am for the respondent number 1. I am for the respondent number 1. The lady, this is the party here. I am not aware of the fact that he has compromised the matter. She has gone outside of the Odisha. He will come by April. He is going to Bangalore, my lord. For that reason,
Who let it there?
No, he was
Hello?
different. I am the defendant here.
You were the auction purchaser. Who was the auction purchaser?
I am the auction party.
You are the auction purchaser.
Yes, ma'am.
Alleging the disposition, forcible disposition.
Yes.
By
It should have been filed.
you succeeded in both the courts.
Yes.
Yes.
So whose appeal is this?
This is my appeal. Borrower's appeal. Original borrower.
My lord,
Husband and wife.
Yes.
I am for the
Matter is compromised.
I am for the respondent number
bank.
2 for the bank. In surface proceeding, the auction was made.
Surface proceeding.
Yes.
What was the amount of default?
My lord, the amount has already been deposited. Amount deposited and he has taken in.
For the amount of default.
Exact amount I
Below
can.
10 lakhs or above 10 lakhs.
So I'll take instruction.
This is for compromise. If my friend.
What compromise? That you will stay?
Yes, that is the.
As owner?
That
free of cost?
No.
Yes.
He has taken the money. But
what taken the money?
That is not recorded here in the compromise petition. But the understanding is some money has been paid outside the court and it is settled. Now he is to abandon his
What
place.
money you have to execute? The sale deed?
Relinquishment deed or sale deed.
Not
Yes.
relinquishment.
Sale
What
deed.
are you talking about?
Sale deed.
That's right.
The
Bank has
sale
already.
has been affected. The deed has been executed. What more?
Bank has already been executed a sale deed in favor of the.
And you filed a suit. You withdrew it. Did not. Then forcibly entered.
That is
suit is maintainable. He has filed a suit for
eviction.
Eviction.
Recovery of
you have taken a plea of surfacing. Trustee. What surfacing action? Everything is over. He's claiming his right on the basis of a sale deed.
No, my lord,
or as an auction purchaser.
my surface.
Surfacing.
No, my surface appeal was dismissed on the
Section 17, you went before the debt recovery tribunal, could not succeed.
Yes.
It was dismissed on the ground of limitation.
Whatever, you know it, Section 17 has a limitation.
Yes.
And they must have issued a notice under Section 13.2 of the surfacing. Then no 13.2a. Then they have taken step under 13.4. Already auctioned the, I think, Rule 8 of the security.
Yes, madam. Yes. Here my humble
interest act. What more?
Here, my humble submission that the appeal is now pending before the DRT, being remanded by the
second appeal. What is your right to remain in possession? Once sale is confirmed, that followed by a possession, then in that event, nothing. And then you came and challenges all the action, you could not. Your suit was dismissed, whatever.
No, suit was
order 7. Plain rejected means the suit was dismissed. That it is hit by the SAPATHY, you cannot challenge the action of the bank or a financial institution.
My surface appeal is pending.
That is section 17.
Being
SAPATHY appeal. You have to go section 17 before the DRT.
I approached.
That's all. Be happy there.
Could not succeed.
Deposited
amount before the surface
debt recovery tribunal.
Section 17 application was dismissed on the ground that I approached late. On the ground of limitation.
And also that you deposited money. There is a condition.
Yes. That money was deposited.
Forfeited by the bank.
Yes. That
or returned.
I deposited in the DRT, it is still there. And the appeal was, the surface appeal was remitted by this court that condonation of delay can be there. This court held
surface appeal. Under what provision?
That is section 17 application.
Section 17 lies before the debt recovery tribunal,
yes,
not before this court. Then
no.
I'm just trying to understand that the law is speak.
I'm sorry, my lord, I couldn't explain. Surface application, that is section 17 application, was dismissed on the ground of limitation.
By the DRT?
I preferred an appeal before the DRAT. DRAT concurred with that order.
Yes, confirms the order.
Then I
appealed to 226.
226 court said no, application for condonation of delay will be maintainable, you reconsider. That
section 17 proceeding.
Yes. That is how the matter is pending before the DRT now. At that stage, these suit or other extra bills, that is why that is the question of law formulated.
No, nothing.
May I pray?
Have you filed a compromise petition?
Yes, I have filed.
Duly signed?
Yes.
By both the parties?
Yes.
Where is that?
That is IA. That flag A.
Have you served the copy on the other side?
Yes.
1793 of 2025. IA.
Where is the compromise petition? Where is the compromise?
IA, it is attached to that IA.
Where?
Page 3, my lord.
Terms and conditions.
Where? I do not find.
That is not a compromise petition.
Page 3 of that IA.
And what do you have to say? This appears to have been signed by your client as well.
Myself, respondent number 1. Myself.
Yeah, respondent, sole respondent. What respondent number 1?
Yes, my lord. My lord, I have not known the operation because my lord, I have not informed about this same. They have my client and put the signature or whatever may be. But I want more instruction, my lord. Like my client has gone to Bangalore, my lord, outside Odisha. I want on the month of April she will come.
There is obvious reason not to inform you.
No, I am not informed.
You will not be informed. Yes.
If that my client has gone to them or not, I'm not aware.
Compromise, that's why he does not inform you.
Yes, my lord. For that is, my lord, this instrument has been signed by respondent number 1 or not. I have to confirm it. But the lady concerned has gone outside to Bangalore, my lord. In the month of April, she will come.
Sorry, the court cannot wait or cannot act at the diktat of the litigant.
My lord, I did not know it, my lord.
We can't.
But I am not aware of the fact, my lord.
She chooses, she will come to the court will be just opening the door.
Because, my lord, that is compromise, my lord. Better, she will back again, my lord. She may say, my lord, I am not able. And that law got a lot, my lord.
What is this?
Mohapatra. Mohapatra.
Well, page 7, my lord. The respondent number 1 has already filed an affidavit. Page 7 of the bill.
So I'm just thinking aloud that who is the advocate who identified that client, that respondent?
That is their local advocate. This
How can it be? Are they holding the power
That's right.
by virtue of Wakalatnama?
That's right.
How can he file a proceeding without a Wakalatnama?
Sorry, madam. I will file a better application here. Because those ladies...
Very interesting. How can a person say prepared by me, identified by me, without a Wakalatnama having executed? And this application, compromise application, must have been filed jointly by both the lawyers, putting their signature. He has not put his signature.
It is a very badly prepared matter. I will file a better application.
Withdraw.
Yes, this IA is withdrawn. I will file a better application.
But it is a joint application. How can you withdraw unilaterally?
No, this application.
After filing,
for the